Hey, welcome to The Explainer. Today we are tackling a huge one, probably one of the most tested topics on the ELSO paralegal exam, confidentiality. My goal here is to give you that mental toolkit you need to really nail these questions on exam day.
So here's how we're going to break it down. We've got 6 parts. We'll start with the big picture, the why, and then we'll get right into spotting the exam triggers, the core rules, and of course those tricky exceptions. Then we'll finish up by looking at the exam traps and the real-world consequences. Let's dive in. First up, the big picture. So why do we even care so much about this? Why is it such a big deal? Well, it all comes down to trust. If a client doesn't believe that what they tell you is completely secret, they're not going to tell you the whole story. And if you don't have the whole story, you simply can't do your job properly. It is the absolute bedrock of the entire relationship. And you got to remember, this isn't just about being polite or professional. This is a fundamental duty. The exam is specifically designed to test your commitment to protecting client information, especially when things get messy or complicated.
Okay, so now let's talk about spotting these issues in those long fact patterns on the exam. There are certain scenarios that should literally make a little alarm bell go off in your head the moment you read them. The word confidentiality should just flash in your mind.
You'll see these things pop up all the time. A family member wants to sit in on a meeting? Ding! Police show up with a warrant? Ding! An old buddy asks you what happened with that case from a few years ago. You have to be on high alert for these because they are specifically designed to test just how well you know the edges of this rule.
All right, this is the part you absolutely have to know cold. These are the core principles, the backbone of every single confidentiality question you're going to face, no exceptions. You just have to have these down.
So, here it is, the big one, Rule 3.031. And the words you need to burn into your brain are all information and strict confidence. I mean, they're not messing around here. It's an incredibly broad and super demanding duty. And this right here shows you just how massive that scope is. Seriously, it's not just the stuff your client whispers to you in a meeting. It's anything you learn from anyone, even from a public newspaper article. It covers every format, verbal, paper, electronic. It even covers the simple fact that someone is your client. That's a huge point the exam loves to test.
So how long does this duty last?
A week? A year?
Nope, it lasts forever. This is a super critical point for the exam. The duty begins the second a potential client contacts you, and it never, ever expires. It lasts through the case, after the case, and even after your client has passed away. It never ends.
All right, so you've got the main rule down. Keep your mouth shut. But what about the exceptions? The times when you can or sometimes must disclose information. This is prime territory for exam questions because it's all about judgment and nuance.
Okay, this slide right here, this is your cheat sheet for the exam. You have to pay close attention to these 2 columns. Must means the law or a court is telling you to do it. You have 0 choice. May is different. That's a judgment call. You can disclose, but you don't have to. Getting that difference right is everything on these questions.
So, let's say you get that court order. You're legally compelled to disclose. What do? You can't just dump the whole client file on their desk. No way. You have to follow these steps. First, make sure the order is actually valid. Then, you disclose only the bare minimum required, nothing more. You assert privilege for everything else, and you have to tell your client what's happening.
Now let's look at probably the most dramatic exception, the imminent risk clause. First thing to notice, it says may, not must. It's your call, and the bar is incredibly high. You need reasonable grounds, not just a hunch, that there's an imminent risk. We're talking something happening right now, not maybe next year. It's a very serious judgment call for extreme situations only.
Okay, let's switch gears and talk about the traps. The examiners love to set up these tricky little questions that look easy on the surface, but they're designed to catch you on a tiny detail.
All right, here's a classic trap. Let's say something about your case is published in the newspaper or it's in a public court document. Is it still confidential? What do you think?
The answer is, without a doubt, yes. And this is a massive trap a lot of people fall into. Think of it this way. Your duty of confidentiality is its own bubble. It doesn't care what's happening outside that bubble. If you learned it while representing your client, it's confidential. End of story.
Okay, let's try another one that plays with the timeline. Someone calls you up. You chat for 15 minutes. They get some advice, but then they say, thanks, but no thanks, and they never hire you. Is that phone call protected?
And the answer is a big, resounding yes, it's protected. The duty kicks in the second they start talking to you as a potential client. That initial contact is sacred. It's confidential, even if you never see or hear from them again. That's a huge takeaway.
Okay, last section. Let's talk about the stakes. Why is this hammered so hard? Because getting it wrong has real serious consequences, and not just for your exam score.
When you breach confidentiality, it's not just one little mistake. It creates this awful ripple effect. First, obviously, you can totally wreck your client's case. But, and this is just as important, it puts you directly in the hot seat for professional misconduct. And let me be super clear about this, a breach isn't a slap on the wrist. It's considered a fundamental failure of your professional duties, and it can absolutely lead to a law society investigation. And yeah, that could mean losing your license. The stakes are that high.
And really, that's what it all comes down to, right? You can memorize all the rules in the book, but what are you going to do when you're actually in that situation? When you have a court order in one hand and your duty to your client in the other? That's the real test. Thanks so much for joining this explainer, and seriously, good luck with your studies.